A woman dies, and 10 months later, her niece is going through the house in suburban Detroit, lifts a couch cushion, and finds a spiral notebook wedged underneath. 4 handwritten pages, scribbles down the margins, and a smiley face drawn where a signature should be. That notebook was Aretha Franklin's will. And in 2026, barely 1 in 4 American adults has anything better than that sitting in a drawer somewhere. On July 11th, 2023, a jury in a probate courtroom in Pontiac, Michigan, took under an hour to decide the couch notebook was a valid will. Under an hour, after almost 5 years of litigation that had set 4 brothers against each other. And the jury got it right, which is the part that tends to shock people. No state in this country requires a will to be typed or notarized or drafted by a lawyer. Michigan doesn't even require witnesses if the thing is in your own handwriting. The smiley face counted too, because any mark you intend as your signature is your signature. Her will was valid. It just wasn't finished, and those are not the same thing. I'm an estate attorney. I'm not your attorney, and the rules change at every state line, so treat this as education and then go get it done properly. But I want to walk through the 8 things that make a will legally valid, and then the problem sitting underneath all of them, which is that a valid will and a plan that actually works are different animals. The numbers first, because they're worse than most people assume. In the most recent national study, 24% of American adults said they have a will. 3 years earlier, it was 33%. It's going the wrong direction, and more than half the country has nothing at all. The biggest group without documents isn't 20-somethings with no assets. It's people between 35 and 54, the ones with mortgages and small businesses and kids who can't tie their own shoes yet. When researchers asked why, the answer from 43% of them had nothing to do with cost or lawyers. They just hadn't gotten around to it. So, step 1 is capacity. 18 or older in almost every state and of sound mind, which is a much lower bar than people assume. Sound mind means you understand roughly what you own, you know who your natural heirs are, and you understand that this document gives your things away when you die. Intent rides along with it. The paper has to announce that it's your will. A letter to your kids explaining your wishes is not a will, however sincere it is. Step 2, put it in writing. Typed is standard and typed is better, but handwriting isn't fatal. Texas and Michigan and a number of other states will honor a holographic will, written entirely in your hand and signed, no witnesses required. That's the door Franklin walked through. It worked. It also cost her family a 5-year trial to prove it worked, which is a hell of a price for a document that took her 20 minutes. Step 3, name your executor and name a backup. This is the person who inventories the accounts, pays the creditors, files the final tax return, and eventually stands in front of a judge on your behalf. Pick the organized one, not the sentimental one, and ask them first. The worst possible moment to discover somebody doesn't want the job is at the funeral. Step 4 is guardianship. And if you have young children, this is the entire reason to do this today. Your will is the only place you get to say who raises your kids if you and your spouse are gone. Skip it, and a judge who has never met your family decides off a docket. Name a first choice and a second choice. Consider naming somebody different to manage the money, because the person who's wonderful with a 7-year-old is not automatically wonderful with a brokerage account. Step 5, say who gets what and be specific about it. Name people, not categories. Then add the clause almost every DIY will forgets, the residuary clause, which sweeps up everything you didn't list. The vacation fund, the truck you bought last spring, the stuff you accumulated after you signed and never thought to add. Without it, that portion of your estate falls back into state intestacy law and gets divided by statute instead of by you. Name backup beneficiaries too, because people die out of order, and a gift with no living recipient is a gift that ends up in front of a judge. Step 6, sign it and date it. The date carries enormous weight, because when 2 documents surface, the later one usually wins. That was the whole fight in the Franklin case. A 2014 notebook against a 2010 will locked in a cabinet. While you're there, add 1 plain sentence revoking all prior wills, so nobody spends 3 years arguing about which version of you was the real one. Step 7, witnesses. Most states want 2 adults watching you sign and watching each other sign. Same room, same time. Here's where people get hurt. Use a beneficiary as a witness, and in many states the will still stands. But that witness forfeits their inheritance, so use neutral people. A neighbor, a coworker, the attorney's paralegal. Never the child you're leaving the house to. Step 8 is the one nobody tells you about, and it separates a smooth probate from a miserable one. Attach a self-proving affidavit. It's a short, sworn statement signed by you and both witnesses in front of a notary that says, yes, this happened, we were all here. Every state except the District of Columbia, Maryland, Ohio, and Vermont allows one. Without it, your executor may have to hunt down 2 witnesses 15 years later, who may have moved or forgotten or died and get them into a courtroom. With it, the will proves itself. Then do the part no statute requires. Put it somewhere findable and tell your executor where. Not a safe deposit box that gets sealed on death. Not under a cushion. A perfectly valid will that nobody can locate does your family exactly as much good as no will at all. Now, I have to complicate the story because you can do all 8 steps flawlessly and still leave a mess behind. Take technology. Roughly 10 states now let a will be created, signed, and stored entirely on a screen. Colorado, North Dakota, Utah, and Washington adopted the uniform version. Arizona, Florida, Illinois, Indiana, Maryland, and Nevada wrote their own. And no 2 of those statutes are alike. Some let your witnesses appear by video. Others still want them breathing the same air you are. New York, meanwhile, demands paper and 2 bodies in the room. So sign an electronic will in a state that permits it, retire somewhere that doesn't, and your family gets to litigate whether your will is a will. I'll admit, I'm genuinely torn on this one. Convenience saves nobody if it invites fraud, and legal scholars warned again this year that when a witness is a face on a laptop, it gets much harder to confirm who's actually in the room, whether the testator understood what they were signing or whether somebody just off camera was doing the talking. North Carolina looked at going fully electronic and backed away, passing an electronic storage law instead. Litigators are already telling us that metadata from e-signature platforms is showing up as evidence in undue influence cases. The same technology that makes signing easier makes coercion easier, and I don't think the law has sorted out that trade yet. Then there's the fact almost nobody wants to hear. A will does not avoid probate. A will is instructions for the probate court, and that's the whole of it. The American Bar Association puts probate at about 16 months and 3 to 8% of the estate. California has a statutory fee schedule that pays the attorney 4% of the first $100,000, 3% of the next 100, 2% after that, and then hands the executor the same amount again. Add a fight, and it stops being arithmetic. Contested probates routinely run $50,000 to $100,000 in legal fees. 2 law professors went through 443 probate files in San Francisco and found a dispute added roughly $17,000 in extra attorney's fees on average, and those were the ordinary ones, not the multi-year wars. The second thing a will doesn't do is control your biggest assets: your 401k, your IRA, your life insurance, your payable on death bank accounts, the house you own jointly with your spouse. None of it reads your will. Those assets pay whoever is named on the form. In 2001, the Supreme Court heard a case where a man died with a beneficiary designation still naming the wife he'd divorced, and she collected the insurance money over the objection of his own children. The form won. It nearly always does, which means the most valuable 30 minutes in estate planning has nothing to do with hiring anybody. Pull up every retirement account and every policy this week and read the beneficiary line out loud. One more crack in the foundation. 1 in 10 Americans with a will no longer lives in the state where it was drafted, and inheritance law travels a lot worse than people assume. Witness requirements, spousal shares, homestead protections, all of it shifts when you cross a border. Meanwhile, the stakes are climbing. An estimated $124 trillion will move between generations through 2048. Probate filings are already up an estimated 32% as boomer estates hit the courts. Only 28% of families think their wealth transfer will go smoothly, and 53% expect delay or conflict or outright confusion. That last figure is the one that stays with me because those families can feel it coming and are doing nothing about it anyway. So what does finished actually look like? Do the 8 steps this week, notarize the affidavit, and stop putting off a document that takes 1 afternoon. Then, if you own real estate, run a business, have children from more than 1 marriage, or hold property in more than 1 state, understand that the will is your floor rather than your ceiling. The upgrade is a properly funded living trust. It skips probate. It keeps your affairs out of a public file anybody can pull. It works while you're alive and incapacitated rather than only after you're gone, and it lets you control the timing. So a 19-year-old doesn't get $400,000 in a lump sum 3 weeks after your funeral. I want to be honest about the word funded, because this is where good plans go to die. A trust only protects what you actually move into it. You have to deed the house and retitle the accounts and assign the LLC interests, and most people sign the binder and never do any of it. An unfunded trust is a beautiful piece of bookbinding that accomplishes nothing except making your family feel betrayed when the court date arrives anyway. And no document, however well drafted, stops grief or greed. I've sat through siblings litigating over furniture. What a good plan removes is ambiguity. And ambiguity is exactly what lawyers bill against. Every hour your family spends guessing at what you meant is an hour billed at $400 against the money you spent your life building. So picture that Detroit living room one more time. Someday, somebody walks through your house looking for the piece of paper that explains what you wanted. Maybe a child, maybe a spouse who is barely holding it together. Whatever they find in that drawer is the last thing you'll ever say to them, so make it clear and make it boring. The cruelest thing you can leave the people you love is a question they have to answer in a courtroom. If this was helpful, subscribe and click the next video on your screen for Know the 9 Reasons Not to Have a Living Will.